At Raju Law, we don't just provide legal services, we provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving you time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello and welcome everyone. I am Sudiksha Bohra and I'm thrilled to have you with us for another episode of Immigration for All, proudly brought to you by Nora Global and powered by Kulatech. If you have been following us, you know we recently gave our Monde Life series a new name, that is Immigration for All, a title that reflects our mission clearly to make immigration knowledge clear, accessible, and useful for everyone, no matter where you are on your journey. And here's some exciting news. Our show is now officially available on Spotify and Apple Podcasts. Whether you are commuting, working out, or just winding down at home, you can now listen in anytime and anywhere. Now, let's talk about today's episode, which dives into a topic that's crucial for professionals and researchers seeking to build a future in the United States. National importance in the ease of specificity, why generalization fails NIW petitions in 2025. The EB2 National Interest Waiver category remains one of the most promising self-petition options available, but it's also among the most understood. In 2025, the stakes are even higher and the migraine for the error even smaller. So generalized vague contribution just won't cut it. Whether you are a scientist, an entrepreneur, an academic, or an industry leader, your ability to demonstrate clear national importance through the specific measurable impact is the difference between approval and denial. And today, we are going to explore exactly what USCIS wants to see and what they won't accept. Introducing our guests, we are incredibly honored to be joined by the two phenomenal experts in the immigration law, both from the Raju Law. Please welcome Chelsea Smith, Supervising Attorney of Raju Law, and Caitlin Moran, Associate Attorney and Team Lead of Raju Law.
Good morning. Thank you so much for having us. We are happy to be here today and to have this important discussion with everyone.
Thank you so much. Hello, Caitlin and Moran. How are you guys?
Doing well. Thank you so much for having us.
Thank you. So I think we can dive into the presentation and you guys can briefly explain everything to us.
Perfect. As it was introduced, today we are discussing a specific topic on why generalizations fail the NIW petitions in the current landscape of 2025. If you are familiar with the NIW or maybe have peers or family members who have pursued the NIW in the past, 2025 is really a new time for the NIW. So today we are diving into this topic. It flows naturally. If you've been following us for the last couple of weeks, we've alluded to these. We've been pointing out vague issues and vagueness as we go along, but today we are discussing specifically generalizations and vagueness as a whole.
Awesome. And again, like we've been touching on this topic throughout the weeks. If you go back to our first presentation 2 weeks ago, I think we really did a deep dive into this as well. Because your proposed endeavor is like the foundation of your petition, you do need to be specific about what you want to do. It's important to show USCIS that you have a precise plan for how you're going to achieve your goals. previously, maybe under previous administration, you might have been allowed to be a little bit more vague about how you're going to reach that goals, but based on updated policy guidance, it really is important to be specific and have measurable goals and use that concise language, not necessarily technical language, but something that the reviewing officer can read and clearly understand what you want to do. So in this presentation, we're going to dive into that a little bit more, and then also have some space at the end to answer some previously submitted questions to kind of further elaborate on this topic.
So that takes us to the first component of vagueness. What we look to in the NIW now more than ever is this idea of the proposed endeavor. For those of you who are familiar, we've talked about this several times, that the proposed endeavor is actually the backbone of the NIW itself. It's what the actual framework is then compared to. So in this sense, it's a vital component of the NIW. Or of a successful NIW, I should say. And that leads us to why concise proposed endeavors are more likely to be successful. Some components of a concise proposed endeavor, you may be thinking, well, how do I know if it's concise? It's probably going to be several pages long. And a successful proposed endeavor may be up to, around 6 pages or so long. We've seen good ones go anywhere from 3 to 6 or so pages. So it can look different for different applicants, but they must contain SMART goals. Well, what are SMART goals? That means it's an acronym for goals that are specific, measurable, achievable based on your background, and they are time-bound, meaning it shows that you have discipline to create a timeline, you have a plan in place. It's not that you're going to achieve these things just maybe vicariously by being a good employee, but no, you have measurable goals that apply to your skills, they are time-bound, and they are achievable based on where you've been in your background already. So this detailed description of your methodologies and tools that you will use is also extremely important. You have to be straightforward with USCIS. It needs to be, you can't talk around what your skills are or what your plan is. You must just get straight to the point. We want to see each sentence have a measurable impact in that proposed endeavor. And lastly, we also need to see a connection to national interest. What kind of problem are you addressing that the USCIS cares about? And it must be specific. It really must have a clear connection that's very much understood with just a few quick sentences about it. The petition itself is where we really build out additional arguments and additional levels of impact. So this proposed endeavor should be really straightforward. It should be a roadmap or a menu of sorts. If you're at a restaurant, think about it that way. It should be very straightforward. You should know what each sentence means and exactly how it is creating this roadmap for your petition.
Exactly. And just touching back on the goals, sometimes I work with people to, work on their proposed endeavor statements, and sometimes their short-term goals and their long-term goals don't really align. And so sometimes it's like you have to explain to people like their long-term goals should build off of the short-term goals. Like it's not two separate categories to say.
That's absolutely correct. And can't say it enough. I also have worked with clients who identify very important, national important, arguments, and they say that they're going to do something that's related to this emerging issue within their field, but they actually, if they look at their experience, which is that achievable aspect of a SMART goal, what they've currently been working on or most recently been working on doesn't align to that exact issue. And so therefore it weakens their overall impact right away. Now that we're kind of branching off from vagueness, but I think that it's important to articulate what a SMART goal is. And so that's why we took a few minutes here to do that. But definitely think about it. Each sentence should be very straightforward, should have a measurable impact to explaining what it is you are doing, how you have exceptional skills, talking about your methodologies. Are you doing something innovative? Say it. If you're doing something innovative, then clearly say it. The USCIS officer will not know otherwise. And that's not for a lack of caring. They're not experts. And similarly, if you're leveraging a multifocal skill set, this is a great place to discuss that and introduce that concept. but your dialogue must be extremely straightforward. Again, we can't talk around it. We must give the USCIS officer a very straight, clear path of understanding what the issue is, what you're doing to address it, which skills you're going to leverage, and in what timeline you plan to achieve it. Making sure that each item is connected so that it creates like a chain link. We don't want a broken chain, right? Or we don't want a weak link in the chain. So this is a good way to think of like a chain reaction of sorts.
Exactly. And then going into some other like common pitfalls that we see a lot in terms of like vagueness or just overall weakness. Again, having that vague or overly broad description of your work and goals. I think I've seen this kind of language used by USCIS and RFEs to say that the petitioner used an overly broad statement. It's unclear what their specific proposed endeavor is. So again, not just saying I want to impact the field of artificial intelligence. That might not be sufficient. You need to say, I plan to impact the field of artificial intelligence by doing X for the result of Y. Like, you want to be as clear as possible.
Yes.
And also being vague about the impact of the work, or maybe even having just a narrow impact. So this is something I think we've seen more recently scrutinized after the January 15 policy update. Especially where petitioners, I think, are currently employed in the United States. So they really need to show that you are reaching an impact at the national level. So it can't just simply, your work or your proposed endeavor can't just simply align with the goals of your current employer, or perhaps the impact, I guess, in like a locality. So sometimes I work with people and they want to say like, oh, I plan to work in an economically depressed area, as the language is used in Danosaur, but it's like, where is that really? And is that place truly economically depressed? If you're saying Los Angeles, that might not really align. So having to be as clear as possible about where you intend to work and what the impact will be will likely lead to more success. And again, failing to show the alignment with the national interests, just to broadly say that, health information technology is important to the United States might not be enough to show like, previous presidential announcements, or to show federal organizations and federal goals that align with that are more successful. And I see this a lot where petitioners want to focus on the importance of their field rather than the actual specific contributions that they plan to make and plan to bring to the United States. So we see this a lot. I mean, a lot of these fields are so important, but we don't need to extol about the importance of artificial intelligence. We really need to extol about the importance of your specific contributions. What are you going to do that is going to have a measurable impact? Are you trying to employ X amount of people in the United States? Are you trying to, reduce fraud by X amount? Like, those are the actionable items that we need to see, or that USCIS needs to see. And then overall, maybe insufficient evidence. Being vague about the impact will also lead to less evidence that can be supported with that. You want to be as specific as possible and to have all these claims supported by external evidence. And again, just going back to that importance of the field. So we're not trying to focus on your job description. That's what I'm just going to. Unless, Chelsea, if you have anything to add, I'll go to the next one.
Yeah, so I think a couple of just quick points to draw out just a little bit further is that when we're talking about these common pitfalls, now this isn't just for, for RFEs or denials. This is when we are onboarding prospective clients as well. These are things that we're addressing from start to finish, sometimes based on client cooperation or patience. We can really delve out these issues a lot with great client cooperation. I think that's really an understated aspect to the success of an NIW petition as well, and attributes to avoiding vagueness. Because if you're working with a group of attorneys and we're coming back and we're saying, hey, your proposed endeavor, your thoughts initially are just far too vague. And they say, well, but what does a successful NIW or proposed endeavor look like? So vagueness generally starts with a proposed endeavor and will be a systematic plague throughout the entire NIW itself. And so when the RFE comes back and it says, hey, we don't have a clear understanding of what the petitioner plans to do, we know that it's not the NIW it's not the root cause in the NIW. We expounded on what we have. So for that part of it, I think that's why you can expect that we're focusing a lot on the proposed endeavor today. I think that's one of the best places to start to remedy vagueness. And if you're coming to an attorney and you're saying, hey, you've worked with several IT software engineers, divulge, like what a successful proposed endeavor looks like. The problem with us curating, or any attorney curating a proposed endeavor for a petitioner, is going to be it lacks authenticity and it lacks experiential knowledge from an expert in the field. I don't know of very many attorneys who are software engineers. I happen to have a small bit of like undergraduate background in science, but that's many years ago at this point. Research has evolved beyond when I was going to law school and all these things. So I'm really not that expert for a science person either, though I can be helpful in other aspects to their journey. You get my point that we're not experts. That's what I'm trying to say here, is that we're not experts. We cannot do this in a way that really will satisfy this new threshold, especially. The landscape is different. They want measurable impact. So what does that mean? Think about if you are doing research. It doesn't matter if research publications are not common in your field. Think about it this way. If you are a curious mind and you're looking to learn something, that is kind of research, right? Think about it that way. Alternatively, if you are a PhD candidate, you probably are very familiar with what research looks like, how the process works, but they're looking for that measurable, tangible impact of not really so much your future plans, but they're also wanting to see something in your past that says that you've distinguished yourself in such a way that you are positioned in a way that you can do this measurable thing in the future too. So time and time again, that's what we're seeing industry petitioners or clients struggling to achieve, is this idea of national importance in a way that overcomes this vagueness barrier that the USCIS is pushing back. They're pushing back and saying vague for a multitude of reasons. Some of them are being lack of descriptions, lack of methodology, lack of timeline, lack of clear pathway for achievability, but they're also pushing back for this other more complex issue of measurable impact. They don't quite call it measurable impact, but that's what they're looking for. They're looking for you to show that, hey, you're working in something that you're passionate about, but you're also making an impact in. Are you doing AI for healthcare that's providing a 10% reduction in or 10% improvement in like patient outcomes? Talk about that. Let's talk about that. Let's talk about, okay, if you're already making a 10% impact, then what's to say over the next 10 years if you continue to implement, maybe you have a master's and a bachelor degree, or two masters that you're working together to kind of create a diverse skill set as a software engineer and an AI specialist or something along those lines. You already have measurable impact saying, hey, the work you've been leading is 10%, improvement in patient outcomes. Well, what's the forecast for the next 10 years? Could you make that 30%? Could you make it 40%? I don't know. Help us make some kind of tangible takeaway for that USCIS officer to really find and understand the value. There's power in statistics, and not just throwing aimless numbers out for the sake of getting a green card, but really digging in and going that extra step to make something extremely tangible, extremely clear for the USCIS officer to understand what it is you're doing in that impact.
Exactly. Now we're going to transition to some questions, some about vagueness, some about the EB2 NIW overall. Let's see. All right, first one. Can I use the same proposed endeavor that someone else used if we are from the same field? Typical lawyer answer depends, but likely not. Each proposed endeavor is unique and tailored to the petitioner, the client. So your proposed endeavor should align with your goals, your career trajectory, and it's so unlikely that it will really align with someone else from your field that might have the same specialization as you or same focus. So the whole key to writing proposed endeavor is to write this, a story kind of like backed by facts and data. You need to make connections from like your technical aspects of your past. If your past work, why was it important at all? Yes. In describing what your specific contributions were. It's so unlikely that will really align with someone else from your field. Again, same thing with writing this future proposed endeavor statement. You need to explain what's so special about your expertise, your specific contributions to your field, your achievements, your education, all the things that make you a good candidate to bypass the perm process. So again, very unlikely that will really align with anyone else from your field.
The next question is, I've never worked in the United States. You talked about being specific. How do I prove my work helps the United States? That's a really great question. There have been instances where it's easier than other times. So there's the classic answer, it depends. There's so many subjectively objective variables. But our answer to this is making sure that you describe how your work has benefited the United States from abroad. So if you haven't worked on any national level projects in your home country, it's going to be more unlikely that you can actually meet this threshold. So one of our thoughts are on this, just to elaborate slightly further, is, are you working at an organization that has a U.S. branch? Are you working on projects that touch the United States? I'm currently working with a client who is working with a United States-based organization, but they're working on Asian projects. And so we really had to reach far to come up with something that we thought that we could really tie back to how they benefited the United States. But luckily for that person, they're working on like those SAP enterprise management systems. So there is some fundamental carryover in that way. Again, that's a really far reach, though, in my opinion. And what I think is going to be difficult for clients who have never worked in the United States or petitioners who've never worked in the United States is just really connecting they're wanting something tangible these days. There's more volume than ever in numbers in terms of petitioners. So making sure that your work has benefited the United States from abroad is going to be a crucial part of that framework that's been, we see that highlighted currently. So definitely part of the application to take into consideration before filing a petition or creating your strategy for filing a successful petition.
Exactly. To be specific, it's not like that residing in the United States is going to be the deciding factor about whether your application is approved. It's your alignment with the NIW framework. And this, I think, falls under the well-positioned prong. If you haven't ever worked in the United States or you don't have any connection to the United States, that is where your application might fail. And again, we see a lot in RFEs, I think, that USCIS will use a language that they're not allowing, petitioners to use the NIW process to facilitate a job search. And so that, again, might fall under this as well.
For sure.
Next question, can I apply with a bachelor's degree from Bangladesh? Again, I would say this depends on your work experience and other skills. So to meet the advanced degree requirement, you could have a bachelor's degree plus 5 years of progressive work experience to get the equivalent in order to apply. But you also might be able to meet the exceptional ability framework if you meet those other categories, like letters from employers to prove 10 years of full-time experience, a license to practice in your profession, or other evidence. So overall, it depends. I think it more so depends on your other skills beyond your bachelor's degree.
Yeah, I think this is a tough threshold too. Typically, the bachelor's degree in 5 progressive years must be accompanied by awards of some kind. It's going to have a really stronger evidence, usually, to be successful. There is a pathway forward, but it really is, it's subjectively objective in that regard, and would definitely be worth looking into the supporting evidence. If you have very strong, compelling evidence, perhaps. We have gotten these kinds of petitions approved, but these people had either publications, high salary, they're working in the United States on US-based projects that were of urgent matters. So I think that those petitions that have been successful that I've seen have had very compelling evidence to support it.
Agreed.
Yeah. Can I write that I want to start a company or build a product in the United States? Will that help or hurt my case? This is a complex question. And I think that generally the American dream comes to mind when people are writing these proposed endeavors. They want to come to America, provide a better place for their family, potentially have a business in our capitalistic market. And so all of these dreams come to play, but they cannot overshadow whatever is individualized about your expertise, what is exceptional about your expertise. Now, there's no hard line that the USCIS says that there's no entrepreneurial endeavors are allowed. But I think that one thing to really consider is that you will be reviewed under scrutiny of being a successful entrepreneur in the United States. So that's a tough barrier. we'll look at your funding. We'll have to petition about your funding, business model, success in running businesses, similar to what you propose to do, as well as whatever your expertise is. And so I think that tends to be a very difficult hurdle to overcome, and it doesn't end up helping as much as making things more complicated. Again, evidence will come into play if you have strong compelling evidence that we can leverage. It's not that it's impermissible. It just tends to get too congested and takes away from the actual core of whatever the person is trying to do. Now, starting a business can have some long-term benefits if you are in an industry that has proprietary aspects to your short-term goals. I think technology people or tech experts is who I think of immediately with this. Starting a business could have some long-term benefits in the sense of giving you a bit of reach nationwide, but even that's limited because the scrutiny is so high now that they don't feel like starting a business by itself is really enough. They want to see some kind of already existed networking connections, like not just starting your business, but more evidence that it would be a successful platform. And that comes primarily through kind of connections, networking, evidence of that through your letters of recommendation or other collaborations. So complicated questions, that could be a whole live session, to be truthful. So we'll go on to the next question.
Perfect. The question is, can I mention collaborations I want to pursue in the future, even if they're not confirmed yet? So honestly, you can mention whatever you'd like, but it's really about what USCIS is going to give weight to. So you can mention that you'd like to collaborate perhaps with U.S., research-based institutions, certain, businesses or employers, but you can mention them, but it's really best if you have evidence of any interest in their collaboration. Yeah. If you discuss, wanting to collaborate with the research institution, but there's no evidence that they even, want to collaborate with private researchers, it's not going to be successful.
Right. And I think that just one last thing to build off of that is going to be if you have been part of collaborations with the NIH or other federally funded grants, if you have multiple collaborations like that in your portfolio, I think that the USCIS is more likely to believe that you could do it again in the future, given that you have multiple experiences in the past, not only achieving those federal fundings, but carrying out the project that's funded under it and then managing it and submitting it for research. I think that creates a more compelling argument and is more convincing than somebody saying, I would like to collaborate in the future. Alternatively, you could go a different route if you already have a state job or federal job and you're already collaborating. I think engineers, bridges, roadways, that kind of projects there. Some of them have federal funding, but sometimes they're working at a state level. And it's more likely than not, if you're already in some kind of organization that has these collaborations, that your research could potentially travel the channels. And so I think that mentioning isn't enough. They're looking for likelihood of coming to fruition. So yes, it's important to mention it if you want to have a broad and systematic long-term effect. But I think that the more compelling argument would be if there's already some kind of pre-existing relationship or experience doing so. For sure.
Agree. Yeah. Awesome. I see some comments in the chat that are not really tailored to EB2 and NIW. So I just ask that you can either call us or email info@rajulaw.com to get those questions answered. And I believe that's all for us. We have our contact info on here, so please get in touch if you have specific questions not tailored to EB2 and NIWs.
Yes.
Thank you so much, Chelsea and Caitlin, for that insightful and thorough presentation. It's truly eye-opening to understand how much strategy, evidence, and specificity go into crafting a strong NIW case in 2025. Now, before we open the floor for our audience question and answer session, we are going to take a short break. Stay tuned. We'll be back in just over a minute.
Are you a leader in your field, an innovator, artist, scientist, or entrepreneur? You may qualify for the prestigious EB-1A Extraordinary Ability Visa, your fast track to a U.S. green card with no job offer required. At Raju Law's Dhaka office, we specialize in building powerful EB-1A petitions tailored to your achievements. With expert attorneys, global experience, and a tech-powered process, we bring U.S. immigration success to your doorstep. Your extraordinary talent deserves an extraordinary path. Let Rajula Dhaka open the door to your American dream. Book your consultation today.
Hello, welcome back, everyone. It's time for our live question and answer session. So I see some of the comments there. I see some of the comments there. Let's shift to some frequently asked questions. We have received them from our audience, including a few that came in during the live stream. So this reflects the real life situations from the people navigating their immigration journey, and we're eager to hear your guidance on them. So the question generally goes like, can someone currently living in Canada on a work permit apply for an EB3 or EB2 NIW petition from there, or is it better to apply from their home country, for example, Bangladesh in this case?
I would ask this person just to get in touch with us privately to discuss all the details of their case.
Okay, no worries. So the next question is, if someone is interested eventually studying in the United States, does applying for an EB-based green card petition like EB3 or EB2 NIW impact the chances of getting a student visa later?
I think what we're seeing right now is that student visas are changing. Right? And so I think that this is an ongoing development in what I've seen in recent weeks. So typically I would say no, but I think that depending on the timing of which the person planned to apply, I think it would be important to have a consultation with an attorney before applying to make sure that your strategy is the best for you. I just think that times are changing, and I think that 2025 is a really time where we're seeing rapid changes. So it's hard to give generalized advice. And just to remind everyone, this is an educational discussion today. It's not really intended, it's actually not intended to be a consultation in that sense. So our feedback today will be very generalized. And if you need specific assistance, you're welcome to reach out to us, because I think that would be the best for accuracy.
Yes, definitely. You can reach out to the Rajula website, or you can directly call in the number that is given below. So thank you. And that wraps up our question and answer session. Chelsea and Caitlin, thank you so much once again for your time, your expertise, and for breaking down this complex topic with such clarity. To our amazing audience, thank you for joining us today, and a special thanks to Chelsea and Caitlin.
Thank you so much. Please join us next week where we'll discuss denial and RFE trends in 2025.
Thank you. So to our amazing audience, thank you so much for joining us today. We hope this episode gave you the clarity and confidence you need if you're considering the EB2 NIW route. Remember, specificity wins. And in 2025, your ability to clearly articulate your impact and national relevance is everything. So don't forget, Immigration for All goes live every Monday, 11 a.m. EST, 9 p.m. Bangladesh time, and 8:45 Nepal Standard Time. That's all for today's episode. Stick around as we close with a few of the latest immigration news headlines. Until next time, take care, and we'll see you next week on Immigration for All.
Welcome to the latest episode of Weekly Immigration News by Raju Law. This week, we brought to you 3 latest developments in the immigration arena. Let's start with the headlines. Update to Form I-693. Department of State releases July 2025 visa bulletin. DHS offers $1,000 and fine forgiveness to migrants who self-deport. Let's get into details. USCIS has issued an important update to Form I-693, Report of Immigration Medical Examination and Vaccination Record, with a new edition dated 20 January 2025. As of June 2nd, 2025, applicants may continue to use either the 9 March 2023 edition or the 20 January 2025 edition, provided the civil surgeon signs the form on or before 2nd July 2025. However, beginning July 3, 2025, USCIS will only accept the 20 January 2025 edition of Form I-693. Applicants should check the edition date at the bottom of the form and its instructions to ensure compliance and avoid delays in processing their applications. Moving on, USCIS has released an important update regarding the adjustment of status filing charge for July 2025 in alignment with the Department of State's July 2025 visa bulletin. For family-sponsored preference categories, applicants must refer to the dates for filing chart in the July 2025 visa bulletin. In contrast, for employment-based preference categories, USCIS has mandated the use of the final action dates chart. Finally, DHS announced that non-citizens who self-deport through the CBP Home app will receive forgiveness of any civil fines or penalties for failing to depart the U.S. Currently, individuals can be fined nearly $1,000 per day if they do not depart after a final deportation order. This is in addition to the cost-free travel and $1,000 stipend that DHS has promised to those who self-deport.